Hey folks, my name is Patrick Hunter. I'm an attorney at the Southern Environmental Law Center, and I want to take a minute to talk to you about my favorite statute, the National Environmental Policy Act, or NEPA. NEPA was signed into law on January the 1st, 1970, by President Richard Nixon. NEPA only applies to federal actions, so actions by the federal government. That includes most actions on the national forest, since national forests are federally owned lands. It also includes actions that involve the expenditure of federal funds. It does not involve actions that occur only on private lands with private funds or only on state lands with state funds. NEPA is just a procedural statute, so it has no substantive requirements. And what I mean by that is that NEPA requires federal agencies to go through a series of procedures before approving a certain action, but it doesn't say that the agency can or cannot take a specific action. So for instance, something like the Clean Water Act says you may not discharge a pollutant to water of the United States without a permit. That's a clear substantive prohibition in the Clean Water Act. NEPA doesn't include anything like that. It's only procedural and is basically just a look before you leap statute. So it requires federal agencies to ask certain questions and make certain disclosures before they take actions. Quick background on how our legal system works here in the United States. If you think of our legal system as sort of like a body, statutes, which are found in the United States Code, are sort of like the skeleton. Those are the laws passed by Congress. They're typically, or I shouldn't say that, but in the case of NEPA, they're not very long. And so what federal agencies do is they develop regulations, which are found in the Code of Federal Regulations, to implement those statutes. And regulations are sort of like the muscle of the body of the law. So statutes are the skeleton, regulations are the muscle. And then after that, agencies develop their own directives and other guidance documents, and that's sort of the flesh. That takes the statutes down even further, from statutes to regulations, down to something that's going to be implemented on the ground through agency directives and other guidance documents. For NEPA specifically, the statute is at 42 United States Code section 4321. There are two sets of regulations the Forest Service must comply with under NEPA. The first is enacted by the Council on Environmental Quality, which promulgates NEPA regulations that every federal agency must follow, and those are at 40 Code of Federal Regulations, section 1500.1. And then the Forest Service also has their own NEPA regulations that they have promulgated and must follow, and those are at 36 Code of Federal Regulations, section 220.1. You can look all of these up. They're all publicly available, and they will give you a better idea of the requirements behind NEPA. Finally, agency directives and other guidance documents for the Forest Service, including those related to its NEPA obligations, are available at www.fs.fed.us/im/directives. NEPA has two main requirements. The first is that the Forest Service must assess the environmental impact of its action before it implements any action. This is the look before you leap part. It doesn't say, for instance, that the Forest Service couldn't go and clear cut substantial parts of the national forest. It only says that they must disclose the impact of that action before they take that action. The second main requirement of NEPA is that it has public participation requirements. So the Forest Service must not only analyze the environmental effect of its action, but it then must disclose that effect to the public and allow the public to give the Forest Service feedback. So this frequently happens through public meetings and comment periods. There are three main ways to comply with NEPA. The first, on the left of the screen, is through a categorical exclusion. This is the process that the Forest Service uses that has the least environmental analysis and the least amount of public participation requirements. You can only use this process for actions that categorically, hence the name categorical exclusion, do not have a significant impact on the environment. So no matter where you implement this action, whether it's in Georgia or Alaska or California or Maine, it does not have a significant impact on the environment, and those activities are categorically excluded from most NEPA analyses. These are reserved for routine actions, things like replacing signs at trailheads, painting district ranger office buildings, and they could involve some fairly minor vegetation management or road or trail work. The second way is this category in the middle of the screen. It's an environmental impact statement. This avenue provides the highest degree of environmental analysis and has the most public participation requirements. If an action is going to have a significant impact on the environment, or if it may have a significant impact on the environment, the Forest Service must prepare an environmental impact statement. The third is the one on the far right of your screen. This is an environmental assessment. An environmental assessment is only completed if it's unclear if a project is going to have potentially significant impacts. Again, if the project may have potentially significant impacts, and that's clear from the beginning, the Forest Service moves directly to preparing an environmental impact statement. But if that's an open question, it first prepares an environmental assessment. If the environmental assessment shows that impacts are potentially significant, then the Forest Service proceeds to complete the environmental impact statement. What frequently happens as part of this process is that during the environmental assessment stage, the Forest Service determines that a project may have significant impacts, and so it changes the project in some way to avoid those impacts. That could be simply changing the project so that it no longer moves forward, the Forest Service no longer moves forward with the most impactful actions, or it could involve adding some sort of mitigation to lessen the degree of harm that will occur from the action. If at the end of the EA process, the Forest Service can determine that the impacts are not potentially significant, then it issues something called a finding of no significant impact, or a FONSI, and can move forward with its project. This next slide highlights the public participation opportunities that are part of the Forest Service's NEPA process. The first one at the top of the screen is the scoping opportunity. This is the public's first opportunity to weigh in with the Forest Service about the project that they are contemplating. It's called the scoping opportunity because it is also an opportunity to explain to the Forest Service what you think the scope of their analysis should be. So should they complete a categorical exclusion, an environmental impact statement, or an environmental assessment? If the Forest Service is proposing to use a categorical exclusion to implement its project, but you think they should use an environmental assessment, this is your opportunity to explain that to the Forest Service during the scoping phase of commenting. But this is also your first opportunity to begin explaining to the Forest Service what you think of their project, if you think they should add mitigation techniques they're not proposing, if you think they should change the project. It's also your opportunity to explain to the Forest Service what the area impacted by the project means to you. Is this an area that you go hunting? Is it an area where you ride your bike? Do you take your family picnicking there? What does the area mean to you? These are all good things to explain to the Forest Service in any public comment, but particularly at the scoping stage. The second stage of public comment comes with the environmental assessment and the environmental impact statement, which is why I've circled them here in red. The Forest Service will publish a draft environmental impact statement and a draft environmental assessment and give the public an opportunity to submit comments on those documents. Those comments can touch on the same issues that you raised during your scoping analysis, or your scoping analysis comments, excuse me, but by this point, the project has been further fleshed out, so you should be able to get a better idea of what the project will look like, what concerns it may raise, and what issues you want to bring to the Forest Service's attention. There is no further comment period for scoping for categorical exclusions, so if the Forest Service is proposing to use a categorical exclusion, your only public comment opportunity will come as part of the scoping stage. The last opportunity to weigh in with the Forest Service is through the objection stage. And again, this only applies to environmental impact statements and environmental assessments. The objection period isn't a typical public comment opportunity. This is a more formal document that you file with the agency objecting to some part of the agency's project. You could say they didn't properly respond to the questions that you raised. You could assert that they are breaking some sort of federal or state law and they need to change the project to comply with it. You could assert that they're violating Forest Service guidance from the guidance and directives that we talked about earlier. One key difference with objections is that you may only file an objection based on an issue you raised in earlier comments on the project, either during the scoping stage or during the EA or EIS stage. So for the most part, you're not allowed to raise new issues. The one exception to that is if your objection is based on information that was not available during a previous public comment opportunity. So what should you think about when you're writing comments to the Forest Service? NEPA requires the Forest Service to think about what harm would be caused by its proposed action, whether it could achieve the same goals with less harm, what experts from other agencies and the public, I might add, think about the project, and generally, what does the public want? Those are all good questions to think about when you're formulating your comments. Other things to remember are that the public is the expert here. You are the expert when it comes to public lands. Frequently, the people that live near public lands know the area far better than the Forest Service, and that's not the Forest Service's fault. It's just that they're not paid to be out in the forest all of the time and frequently get moved around the country to other forests and don't have an opportunity to get to know these areas like the public does. Tell the Forest Service about special places that you visit on public lands and what you think the Forest Service should do to manage them or not manage them. As part of the NEPA process, it's also important to ask questions. If anything's unclear, ask the agency to clarify. NEPA requires the agency to respond to questions that you raise in your comments. You should feel free to provide alternatives. As part of NEPA, the Forest Service will explain its overall goal for a project and then look at different ways to fulfill that overall objective. Feel free to suggest your own alternatives as different ways to go about achieving that goal. And finally, I can't touch on this enough, that it's always important to explain to the Forest Service what these areas that are being impacted means to you and how you use them and how you'd like to use them in the future. That's a quick overview on the NEPA process. Good luck with your commenting.